Welcome to the INREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, good morning, everybody. Today, our topic is specific performance actions in real estate. I'm Andy Fowler, and I'm here with Sean St. Clair.
Morning, everybody.
If you're new to the show, give us a like. Make sure you subscribe to our channel. Also, we want your feedback, so leave us a comment below, whether that's in Facebook, YouTube, or wherever you're watching. With that, Sean, let's go to you. Give us our legal update.
So today I want to talk about utilizing membership interests in LLCs to effectively convey title to real estate. So in the creative financing arena, what I see is kind of an unused strategy is the use of LLC membership interests to actually convey title versus actually conveying the title to real estate. And so what I mean by that is when individual owns real estate, they own it in their individual name. And then for them to convey it, they use some form of deed, whether that's a warranty deed, a quitclaim deed. But they basically take the property and actually deed the title of the property to the new owner. So, and that's great, that works. But there's certain circumstances where maybe you don't want to do that. Maybe your financing is in such a way that, you're concerned of a due on sale clause. But then when you review the loan documents, you realize, well, it doesn't limit or doesn't hinder my ability to convey, say, a membership interest in a limited liability company. Or maybe, you're looking to do some form of carry back financing. So you own it, but somebody else wants to buy it. And instead of going through an additional closing or a new closing, you're going to do the carry back, but instead of actually deeding the property, you're going to convey a membership interest. And so the way that would work is instead of an individual owning the property, it would be owned by a limited liability company. So we talked in our last episode on setting up and using corporations and corporate structures, right? And we talked about the idea that limited liabilities and corporations are kind of their own, being, if you will. Like they can own property, they can enter into contracts, they can do those types of things. And so you would have the limited liability company actually be the owner of the property, and title would remain in the limited liability company, but the owner of the limited liability company would change, right? So let's say that through my limited liability company, I purchase a property from a seller and I own it, but I want to sell it to you, Andy. You want the property, but instead of going through another escrow, what we do is say, okay, well, you want the property. You want to be able to control the property. You want to have all the rights associated with that. Well, instead of my LLC executing a deed to you and conveying the actual title, what we could do is I could say, okay, well, why don't you do this? Why don't you substitute for me as the owner of the limited liability company? And so I would then convey to you not a real estate interest, but a personal property interest, right? I would convey to you a membership in the LLC and say, okay, now you're the 100% owner of the LLC. Well, effectively now you own the property because the LLC owns the property and you fully have 100% control over the LLC. At that point, you can do with it as you may. And so let's say even further that you come to me and say, well, I want to buy this property. It's worth $200,000, but I only have $20,000 to put down and I want to finance $180,000. Well, we could do that as well, right? We could take the 20 and we can do a membership interest purchase agreement along with a promissory note, a security agreement, secure that with a UCC financing statement. We could even secure it by the property via deed of trust,
Sure.
if we wanted to. but we could secure it. But instead of it actually being, your traditional carryback that is maybe governed by certain regulations, the sale of a membership interest, may have other regulations that, anybody should look into and figure out, the different things, like we talked with Paul Vincent about securities and things like that. But, there are certain lending regulations that likely don't apply to the sale of a membership interest, but they do maybe to like carryback financing on the sale of real estate, if you will.
Right.
So that is another tool in an investor's toolbox that they can utilize to structure a transaction, is basically figuring out a way to, utilize the ownership and membership of an LLC to effectively convey title to real estate versus actually conveying the title to the real estate by way of a warranty deed.
Are you finding certain situations that investors, or certain situations that lend itself to this form of transfer versus just the classical transfer by deed?
Yeah, one area that we'll probably start to see this in more if we do see a market shift, which some people are predicting, other people say no, we're probably not going to see depreciation like we saw in 2009 and 10.
Mm-hmm.
But let's say short sales come back into play. Well, you can't assign a short sale. You can't wholesale a short sale because of the fact that the bank is approving the sale to this particular buyer.
Right.
Now, it's subject to the bank's approval, but the buyer could be an LLC, right? And so the buyer is the LLC, and you could then have in play a membership interest purchase agreement that's effective upon the LLC taking title, right? So in essence, it allows you to assign or wholesale a short sale when you otherwise normally could not do so. There's also lender regulations on, transfer of title, right? The due on sale clause. Now you have to look at the loan documents because, there's going to be unique provisions, and some loan documents do say that the sale of an ownership of whoever the borrower is, or the conveyance of the actual membership or ownership, would invoke the due on sale clause. Other loan documents don't have any of that. It's simply, if you transfer title to the property, you invoke the due on sale clause in that case. So in that scenario, you could avoid invoking the due on sale clause by selling the membership interest in the LLC, if you will, if your loan, doesn't prohibit it, if you will.
Sure.
You have to review those loan documents. But so those are two examples. Others, like we talked about, is a different way of doing basically seller carryback. So you as the investor own the property. You want to sell that property to a buyer who you're going to do carryback. Well, maybe instead of doing your traditional promissory note, deed of trust, warranty deed, or even an agreement for sale or a contract for deed, instead of doing that, you enter into a membership interest purchase agreement with the buyer, and you do it that way. So all of those are scenarios that potentially, subject to certain regulations and contractual provisions and things like that, you could utilize that strategy as another means of accomplishing the same objective.
Interesting. All right. Thank you so much, Sean, for the today's legal update. Today's topic, what we're discussing today, specifically, no pun intended, are specific performance actions, a tool oftentimes used by lawyers and used by real estate investors, and we thought an important topic worth discussing in the context of real estate investing. With us today to discuss the topic, we have attorney Brian Locker. Brian is an attorney with Fowler St. Clair. He works out of both Arizona and Georgia. Brian, thanks so much for joining us.
My pleasure. Thanks, guys.
Brian, give our listeners an idea. What states are you licensed in to practice law?
So I am licensed in both Arizona and Georgia. Practiced the bulk of my career out of Arizona, but moved to Georgia and was licensed there in 2018 and have been running the office in Georgia there ever since.
Give us an idea about your areas of practice.
So historically, I've done a mix of both real estate law and general business, litigation, general matters, that sort of a thing. In recent years, I've focused my practice to the point where I'd say 75 to 80% of what I do day in and day out is deal with litigation and transactional issues arising in real estate disputes.
So today our topic is specifically on specific performance actions, and we know you do a lot of specific performance actions for Fowler St. Clair. Tell our listeners, what is a specific performance action?
So at its root, a specific performance action is an extraordinary remedy, meaning it's a remedy that is not often granted unless you meet very certain criteria, but it is a remedy in which a party to a purchase contract can have a court force the other party to a real estate contract to perform what they were doing. So whether that's the seller or the buyer, and depending on the state, there are different limits on which party can be forced to specifically perform. But at the end of the day, it's when one party wants the other party to do what they said they would do under the contract.
Hey, Brian. So you mentioned the idea of maybe forcing a buyer to perform. My understanding is in Arizona, that's not really something that's doable or possible, and that you're pretty much limited with the seller. But you said that is it any different in Georgia?
It is. So in Georgia, they recognize the possibility of having a buyer specifically perform. And that, you're right, that's different than in Arizona. Arizona pretty much forecloses the option of specific performance on the part of the buyer. And the justification for that is makes sense, right? Because the reason why specific performance is available in the first place is because the whole idea of allowing a seller to force to be forced to sell their properties because there's something very unique about the property that they're selling. And so a court, assuming you qualify and meet the other criteria, you can force that seller to sell that very unique thing that you wouldn't be able to otherwise get in the form of money and that sort of thing. It's not replaceable. On the flip side, right, specific performance for a buyer is very unusual because you can, as the seller, you are simply expecting money from the buyer. And that's something you could receive from another buyer, potentially. And so, so Georgia does recognize the remedy of specific performance for a seller, although it's not common that a court will actually award it.
Well, just the logistics of that seem, very complicated. Meaning, if a seller doesn't perform, assuming the seller's not bringing money to the table to pay off a loan or to, do different things, like any credits or amounts that will be used to maybe repair the property or concessions, closing costs that the seller would otherwise pay, normally are paid out of the seller's proceeds. So normally you don't have a seller showing up to the closing table with a check, but you do the buyer, right? But so a seller, you can basically have a court order that says, hey, look, escrow company, you can go ahead and close this and, use a real estate agent that's appointed by the court or a fiduciary or somebody appointed by the court who can sign if the seller refuses to show up to the closing table and sign the documents, right? So you can basically have everything executed as though the seller were there, even though they're refusing to comply or cooperate.
Right.
And then any type of concessions, escrow agent, the court orders the escrow agent take it out of the seller's proceeds and then have a check sitting there for the seller for the remaining amount, type of thing. And that's all very doable.
Yeah.
But how do you go to a buyer and say, hey, look, you're buying this thing for 200,000 and show up with a check? You know what I mean? Like, how do you do that? And it's hard enough. You and I both know what it looks like to enforce a monetary judgment.
Right.
You're chasing people all over the place, right? So, if the buyer's like, I'm not going to show up and do this, I don't care what you say, court. I mean, how would the court enforce that?
Well, we often say, and it's not unusual for me to, as I'm explaining remedies to a client, right, to explain, look, you can go get a judgment, but if they don't have the assets, or that judgment may only be as worth the paper that it's written on or printed on, right? And so, I think you're going to run into the same issues with a specific performance judgment against a buyer.
Yeah, and that's why one of the primary reasons that, in addition to what you said, as far as property being unique and things like that, that's one of the things that we see in Arizona, why specific performance is not generally available to a seller, because, how do you enforce them to, or force them to, the buyer to really perform? There's no legitimate or easy mechanism.
Yep. Absolutely.
Brian, let's talk about what might be preliminary conditions before bringing a specific performance action. So the seller they've refused to go forward. I still want this property. I want to enforce their obligations to buy the property. Are there conditions or preliminary considerations that need to be fulfilled, whether by law or by contract, that we need to be aware of before it's filed?
So, I mean, what we're going to want to do in any case where a buyer comes to us looking potentially at a specific performance action is we need to first take a look at the contract, right? We need to see, all right, what's happened? Have all the conditions that the buyer needed to meet, have they been satisfied? Is it time for the seller to perform? And if not, then we need to take a look at what we as the assuming we're representing the buyers, what we need to do to resolve those issues. We need to take a look and see if are there title issues. I mean, there's any number of things that could make a specific performance action premature. But generally speaking, under the law, a specific performance won't be available until the performance for the seller is required under the contract.
So how often do you see, or do you run into situations contractually where the seller has a right to cure, and where early action might constitute an anticipatory breach or something to that effect?
Yeah. So by the time we get involved, generally there will have been inaction on the part of the seller, right? The seller will have done something or failed to do something, which is why we're even involved. And so the buyer comes to us and says, they're not talking to us anymore. Our transaction coordinator can't get a hold of them. We got a text message saying that they've had a change of heart, or whatever the case may be, right? Something has happened, or the seller's failed to do something. And so at that point, we need to look and say, look, does your contract have a cure notice provision in it? And if it does, because many of them do, the standard Arizona real estate contract has a cure notice provision, and many private investor contracts have cure notices. And so we need to make sure that we resolve that before moving on to the next step. And that often is an opportunity to send out a demand letter combined with the cure notice to make the seller aware that that we're involved and we intend to seek the specific performance remedy.
Hey, Brian, talk to us about what a buyer should expect if a seller chooses to perform within that, cure notice timeframe, if you will.
Have all your ducks in a row. be ready to go to the closing table if if we're right up against the closing date on a contract, and all of a sudden we send out, we're thinking that we're going to litigation, specific performance, and then all of a sudden, your seller turns on a dime and says, all right, I'll close. And the closing date's a couple days out, but they're saying, I'm not going to sign any extension. I'm not going to extend close, but I will sign on this day.
Right.
You better be ready up until that closing date to perform under that contract. And so logistically, a buyer should be prepared for that possibility.
Well, let's talk Arizona. So the contracts here in Arizona tend to have a 3-day cure notice. Some have different. We can talk about that a little later on. I like to see a longer cure notice provision in there, but then the carve out an exception for sellers' lack of performance. But if you have, say, a 3-day cure notice, you send the cure notice to the seller shows up within those 3 days and signs the paperwork, then you don't perform, the seller then has the ability to cure the buyer, right? So if the buyer doesn't perform upon the seller executing everything, then the seller can send the cure notice, which then gives the buyer 3 days to perform at that point?
Assuming we're talking about the standard Arizona purchase contract, that would, basically you've got a 3-day buffer. And Sean, we've run into situations where that 3-day cure notice comes in at 5 o'clock on a Friday. Nobody's open Saturday, Sunday. You better be ready to close on Monday.
Right.
So there's all sorts of craziness that can happen in those short time frames.
Yeah, not to mention holidays, where our clients have thought to send a cure notice like right before a holiday weekend.
we got one coming up this weekend.
Yeah. And so, you think about it here in Arizona, let's say, a seller wants to avoid a contract. I mean, in theory, they could send a cure notice at 11 o'clock. So with this coming weekend, right, they could send it 11 o'clock on Friday. So after close of business on Friday, and then it's 3 days, but then if it falls on if the closing falls on a holiday, then it rolls over, right? So if they send it at 11 o'clock on Friday, then you have Saturday, Sunday, Monday, which is a holiday. You have to close on Tuesday. You literally have 1 business day to make it happen. So if you're a buyer and you're going to pursue the contract and the seller wants out, the advice needs to be, look, buyer, you better be ready. And if you've assigned it and you're counting on an assignee to close, you better be ready. Either you or your assignee needs to be ready at a moment's notice to put money in escrow. Because I think that's what you have to do, right? I don't know that if the title company comes forward and says, oh, well, we can't close it. Well, they're an agent of both sides. So, the seller's agent isn't able to close as well, which means seller's not able to close. Like if they can't prepare all the documents or whatever, that type of thing. But you have to be ready to show up, on a moment's notice and drop whatever amount you need to close that transaction into escrow. Otherwise, specific performance or not, that contract's canceled.
Yeah. It can get really hairy, especially if the seller has retained an attorney and can look at this more strategically, right? Oftentimes sellers will remain unrepresented through that process.
Right.
And so they're not thinking about it like we would as attorneys and how you can do that. But man, if they go and retain an attorney and they look really carefully at how all that would need to play out, a buyer should expect that could happen. Yep.
Yeah, for sure.
Brian, a lot of our clients, a lot of our listeners as real estate investors like to get into real estate via an assignment. Assignments are a big part of the industry currently, in the event of an assignment, who can pursue the specific performance action? Can you still bring up specific performance action?
Well, I think a lot of that's going to depend on the way that the assignment is structured, and whether the remedies are available to you under the assignment agreement that you have with the original buyer. And so we would want to take a look at how that works. But presumably, the way that many of these assignments are worded, you have the right to pursue whatever remedies are available up until the expiration of that assignment. And so, unless there's some language to the contrary, as long as you have the right to purchase that property, you have the right to force the sale of that property.
Yeah. So just to piggyback on what you were saying, Brian, as you know, my practice is transactional in nature. And so I do a lot of purchase contract and assignment drafting. And the two things I do in my assignments, to allow the original buyer to control the transaction up to the date of closing is, number one, I put in a provision which states that the original buyer retains the right to pursue the performance of the contract in its name against the seller, right? So that's, even though we're assigning the contract and a bundle of rights, one of the rights I'm pulling out from that bundle and retaining with the original buyer is the ability to specifically enforce or seek specific performance of the contract against the seller in the original buyer's name. So they still control that component of the transaction. The concern with that gets back to the idea that you want to make sure that the assignee has the ability to perform if you're relying upon them, right? So even if you obtain that judgment for specific performance, and then the seller says, okay, I'll sell, you have 3 days to do it. You need to make sure that the assignee is in a position to close. So I also then put a provision in the contract that states that in the event the seller, or in the assignment, in the event that the seller refuses to timely close escrow, and the original buyer is going to pursue specific performance or seek to enforce the contract in their name, they have the right to cancel the assignment by refunding the earnest money to the assignee. That way they fully control it at that point, right? They're not counting on an assignee to perform, assuming that original buyer can perform and they have the resources and ability to perform, which, raises some questions too about, wholesaling and entering into purchase contracts, without the ability to perform at the time you enter into it. I mean, that raises a whole nother, ball of wax and issues there. But as far as, the original buyer, if they have the ability to perform and they can perform, reserve the ability to basically take back the transaction and cancel by refunding the earnest money to the assignee. And then the third thing that we put in there is that if the assignee doesn't perform by the original closing date, that it's automatically canceled and reverts to the assignor, so that the original buyer can, find another assignee, and then the seller who should have a 10-day cure notice versus a 3, then you have basically 3 days to perform, or not 3 days, 10 days to perform in that case. So those are the kind of what I like to see in the assignment, that basically allows that original buyer to control the transaction throughout until the actual, closing date, and the assignee, shows up with the money on that date.
Perfect reason why an investor should have a really good set of forms that have these kinds of provisions in them, because oftentimes I will see basically single page, not even, half page assignments with just sort of skeletal assignments in them that technically legally work, but don't have these kinds of things contemplated. that, as someone who litigates these types of issues, is constantly saying, man, if we had the ability to go in and do XYZ, it would solve a lot of issues. So,
Brian, what kind of documents go into the filing of a specific performance action?
So at the very basic level, we have a civil complaint. So it's just the document that is filed with the court that asks for the relief that we're requesting. It'll have allegations that we lay out that sort of give the court some background on the contract between the parties, the issues with performance, and then sets out our causes of action. So we have the complaint, and then we'll have a summons, which is just a document that either we prepare or the court will prepare, depending on the court, and that we will then serve on the seller with the complaint, those two documents together, and those are the primary documents. Depending on the court you're filing in, there may be other documents that also need to be served. So like in Arizona, we have something called a certificate of compulsory arbitration, and so there's some other things that could come into play as well. But those are the primary documents, and then oftentimes, depending on, like we talked about before with the cure notice, if we didn't have a cure issue and we hadn't sent a demand letter up to this point, then oftentimes what we'll do is we'll also, at the time we serve this summons and complaint, we'll also prepare a demand letter, because the complaint's a lot of legalese, and sometimes, especially if that seller is unrepresented, it can make sense to have a demand letter that's written in more normal English that sort of explains, this is what we're doing, this is what this means, and what we're asking you to do, and have that served on top of the other documents.
So, one of the things I hear from clients, especially real estate investors, right, who are in this to make money, that's why they're doing what they're doing. When they hear the idea of filing anything with a lawyer, it sounds expensive. So what are alternative solutions? A demand letter is obviously an alternative solution. But it sounds like your practice is to, when you utilize a demand letter, to utilize it in addition to the filing of the complaint and the service of the complaint, not prior to all of that. Is there an exigency at play? Is there a reason why the demand letter isn't just sent and then you just wait to see what happens before doing the work on the complaint?
Yeah, I mean, obviously, what Sean and I were just talking about, there are oftentimes in purchase contracts or assignments or whatever is at play in this particular transaction, there are timing issues. We have clauses in many contracts that say time is of the essence, and generally speaking, the longer you wait to initiate your remedy and file a lawsuit, the better the argument becomes, the better the argument is for the seller to argue whether it's the expiration of a deadline, non-performance, some other technicality, whatever it is. And so, to your point, exigency, we generally find, and we do quite a bit of this work, we generally find that moving to the specific performance civil action earlier results in much faster resolution to the overall claim, and actually ends up saving the investor money, because you are foreclosing, for lack of a better term, many arguments that sellers will make by jumping straight to the lawsuit. Because oftentimes the best arguments that the sellers have are that the investor waited too long, that they sat on their rights, and at the end of the day would sending a demand letter and waiting 2 weeks, completely ruin your chances at a specific performance action? Probably not, depending on the contract. But we just find that by moving as quickly as possible and moving as quickly as the contract allows us to move, we find that resolution is just much faster in those circumstances.
Brian, what happens in a circumstance where you were to send the demand letter and then you're hanging out waiting 2 weeks and the seller then sells the property to a third party in those 2 weeks? What would that mean? And let's assume that the purchase contract did not allow the buyer to record a memorandum. And so and rightfully so, the buyer did not record a memorandum against the property. They just, said, hey, let's get the demand letter out, see what happens. Cause I don't want to either pay the attorney's fees, or I don't want to, go full bore right now. And we're going to hang out. We're going to wait 2 weeks. But then the seller finds a buyer, doesn't disclose, the fact that they have it under contract with somebody else and there's nothing of record showing that, and they sell it to this third party and close, escrow in those 2 weeks. What does that look like?
I don't have to imagine. It has happened multiple times.
Yeah, right.
Look, that party who purchased the home from your seller, again, using your facts, meaning the seller, that third party buyer didn't know about us as the first buyer. There was no memorandum filed, nothing like that. That third party buyer is called a bona fide purchaser for value, and that home is gone for all intents and purposes. We can seek damages from the seller, but specific performance is effectively off the table unless we can determine some of these other things that you were talking about. Did they know? Did they have reason to know? But outside of that, assume that house is gone.
So Brian, let's talk about one of the documents specifically in preparing the specific performance action, and this deals with the idea of the seller selling to somebody else. But talk to us about the lis pendens. What does it accomplish? And I'm assuming this question assumes kind of Arizona practice, but is there a similar process in Georgia as well?
Yes. So a lis pendens, the purpose of it is simply to put third parties on notice that you, as in this case a buyer, are have a claim to this home. And whether that's through a purchase contract or otherwise, generally in our practice, it's because we have a purchase contract signed between ourselves and the seller of this property. And so when you file a lawsuit, assuming we don't have a memorandum this file or whatever, we would, in addition to filing the lawsuit, we go and record a notice of lis pendens. And that should have the effect of preventing the sale of that property to third parties. So the way to think about it, a lot of investors are familiar with the idea of recording a memorandum. You have a seller who is getting skittish, has indicated they don't want to perform. And so a lot of investors are familiar with, they just go and record a memorandum against the property.
So I'm a real estate investor, and this lis pendens thing just sounds awesome. I'm going to go record it and put the whole world on notice. Can I do that without a lawsuit?
Right. So, no, a lis pendens requires a pending action. That's where the word lis pendens comes from, is it's basically notice of pending action. So where a lot of investors will use memorandums of sale, that doesn't require a lawsuit to be filed, but does require in Arizona does require specific language in your contract in order to file it without violating Arizona law. A lis pendens can be recorded anytime after you file a lawsuit. So that is another, if your contract with the seller does not allow you to record a memorandum, then that, we were talking about exigency earlier and the need to act quickly. That is another reason why we may need to act quickly, is you don't have the ability to go record a memorandum. And so we need to go record a notice of, we need to file a lawsuit, record a notice of lis pendens to hopefully prevent the sale of that property to a third party. Because once you record a memorandum or record a notice of lis pendens, that should get into the chain of title for that property, so that if the seller tries to sell to someone else, it'll get flagged in a commitment for title and prevent that transaction with the third party from going through until the issue is resolved.
Brian, once your paperwork, so your complaint, your the other documents that are associated with filing with the court, summons, lis pendens, maybe a demand letter, once all of that is provided to a process server and served upon the seller, and now they have it in their hands and they're aware of the action, talk to us about the deadlines both in Arizona and Georgia for filing or an answer. How long does the seller have to answer the complaint?
So it depends on where the seller was when they were served. But in Arizona, if the seller was served within the state, then they have 20 days to respond. If they were served outside the state, they have 30. In Georgia, you just get 30. And so that is the waiting period, where, either they will respond in some way. I mean, that's generally what we hope for, right? Is that we hope during that period of time, they'll go hire a lawyer, or even better, contact us and let us know that they're going to sell, in an ideal world. But that's the time that we have to wait before we can take the next step towards default if they don't answer the complaint.
So roughly, and obviously this isn't a scientific number, but in your experience, what percentage of these cases resolve or settle from the date that service is accomplished to the date that an answer is to be filed? What percentage, successfully settle or resolve themselves?
Quite a few. So I would say 60+% will resolve in that period of time between when we file and serve the lawsuit and when an answer is due. Probably about 60% of the cases will have some sort of resolution in that time period. The other 40% can be split in a couple of camps. One camp is legitimate contested actions where the seller has legitimate contract issues, and it becomes a contested litigation, and that's its own sort of animal. And then other cases that do resolve, they just take a little bit longer to resolve. So.
All right. Well, we really appreciate your time, Brian. That gives us a lot to think about in bringing it, or investors considering bringing specific performance actions, and what they're and how that's going to play out, how they might use that to leverage getting the deal done. Where can our listeners find you?
I can be found at fowlerstclair.com. I have a full practice in the Atlanta area as well as in Phoenix, and the regular socials. Although I'm not terribly good at responding on social. So find me on the website. You can drop me an email or give me a call, and I'm happy to discuss these issues.
Well, we really appreciate you being with us, Brian, to talk about specific performance actions. Look forward to doing this with you again.
Thanks, Brian.
Thank you much. All right. Thanks, guys.
All right, have a good one. All right, everybody, thanks for being with us today. We're gonna we want to talk. Brian had to be off on another event, but we did want to talk through a few more of the issues relating to specific performance actions. And just jumping off, Sean, where Brian kind of left, the other side's answered, right? We had hoped that it was going to settle. We had hoped we were going to get this done quick. They've answered there's a contested issue, or maybe there's not really a contested issue, and the other side's just decided to dig in and fight this thing. Due process allows them to do that. What are our next steps?
So I'm not licensed in Georgia, so I don't know what the next steps would be in Georgia.
Sure.
But here in Arizona, Arizona is very lenient with default judgments and answer deadlines. And so what would happen is, let's say the complaint was served in Arizona, 20 days goes by, no answer. So the seller doesn't answer. Well, the seller's going to receive another bite at the apple. So you have to send out to either the seller or both the seller and the seller's attorney, if the seller is represented by counsel or you're aware of representation out there. You send a application for entry of default and a affidavit of default, basically saying, hey, look, seller, you did not answer within the 20 days. And now you have 10 additional business days to file your answer from the date that we've sent this application for default out. And if you don't do that within 10 days, then we have the right to pursue a default judgment from there. So basically, you have 20 days plus another 10 business days. So you have about 35 days if everything goes smoothly and you're hitting all your deadlines before you have the right to even obtain a default judgment. And then that process, has some time periods as well. In fact, you do some litigation. So, what does it look like to, nowadays to go down the default judgment route, and, how long does it take to have a commissioner, consider it and sign off on it and that type of thing?
Yeah. And of course that can vary from season to season, right? Depending on, in COVID, it might have taken a long time. Although now that there's virtual appearances with the courts, they can facilitate that some quicker. But obviously default would kind of be the next nice alternative, given that the relief being sought in this kind of case is going to be specific performance. That is the kind of default judgment that's going to require a hearing. So your lawyer's going to go into court to obtain that default judgment in the final hearing. But that would be optimal in terms of time to deal with that. However, that's not always the case, right? Sometimes we get somebody who answers. So let's talk about, well, let's back up even before we get into that. One of the issues any investor is going to be concerned about is recouping as much money as they can. How are attorney's fees factoring into this?
Yeah, great question. So the way the attorney's fees would work is the purchase contract should, assuming it has the right provisions, it should say that the prevailing party in any action arising out of that contract shall, not may, but shall be awarded their reasonable attorney's fees and costs. So what that means is that the buyer will have to front those fees to their attorney. So they're paying those fees up front. They're paying the filing fees, the filing costs up front. But should they prevail in the lawsuit, then in that case, the court does have the ability to award fees as part of the judgment. Now, whether or not those fees can be recouped from the sale of the property may depend upon whether that property is homestead property or not.
True.
Because if the property is a homestead, then, a monetary judgment, which the fee award would be a monetary judgment, it doesn't attach to the homestead and it's not recoverable from the proceeds from a homestead property. Now, From a drafting perspective, we can try to go around that by basically stating in the contract that any fees awarded in favor of the buyer shall be paid from the proceeds of the sale of the property, and the buyer has, a lien or a right to those fees. And if you do have that language in the contract, you're going to want to ask the court as part of the judgment process, and specifically, put in your proposed form of judgment language saying that those funds are paid out of the sale of that property. If you don't have that language in there, even if it's in your contract, you likely don't have a right to receive those funds from the homestead sale.
Sure.
So you're going to want that language in the contract, and then you're going to want to have similar language in the judgment. Now, let's say hypothetically that you don't have an attorney's fees provision in your contract. Well, in Arizona, we have a statute, ARS 12-34101, which says that in any action arising out of let me back up. I said that wrong. In any contested action arising out of contract, the prevailing party may recover their attorney's fees. So there's two words in there that we need to focus on. The first is may, which gives the court the discretion to award attorney's fees or not.
Mm-hmm.
Now, most courts will award attorney's fees under that statute if the action is contested. That's the key words, right? Contested is a major problem. If the seller doesn't perform, you file the lawsuit, you serve the lawsuit, the seller doesn't answer, you serve your default documents, the seller still doesn't answer, and you go and you obtain a judgment by default. Well, our cases in Arizona interpreting that language contested have very clearly said, and this is the law of Arizona, judgment by default is not a contested action. They let it go by default. They didn't contest it. Therefore, you don't get your attorney's fees in that case. And so if you don't have the attorney's fees language in your contract that says that the prevailing party shall be awarded their attorney's fees, you're not going to recover them in a default if you obtain judgment by default, and you're just out those fees. You paid your attorney those fees. They've obtained the judgment for you. You're going to end up with the property, but out of the profit that you would normally make, you're going to have to, you're losing a little bit because you're going to have paid attorney's fees to get to that point.
You're going to eat it. Yeah.
Yeah.
And as an investor, you're really, that's just kind of baked into the cake. Fortunately, a default is a relatively predictable amount of work for a lawyer to do. Sometimes they might be even able to flat fee it and to prepare that. Let's briefly talk about a contested action. So they have answered. Now we've got a fight on our hands. Both sides have appeared. What's the quickest way to get this thing done?
So basically, the next steps would be you have to prepare and serve a disclosure statement. And so basically, a disclosure statement lists out all the facts that support your case. You list out all the law that supports your case, all the exhibits or evidence that you have to support your case, all the witnesses you have to support your case. And there's some additional information that it requires, but basically you lay that out, and it's a pretty comprehensive document, and you have to serve that on the other side. Then you also have the ability to file what's called a motion for summary judgment. And it basically is a motion that you put before the court and say, look, court, here are the uncontested facts. Here are the facts that everyone agrees upon. Everybody agrees upon that we have a purchase contract. Everyone agrees upon that it's for this specific property. Everyone agrees upon that it's for this purchase price. And you lay out all those facts that are not in dispute. And you say, look, judge, based upon these undisputed facts, there is no question that I receive judgment, that there's nothing that they can come back with that is a contested fact that would be something that could go forward to a trial and that we need a trial on. But we can take the uncontested facts, we can look at them and say, oh yeah, based upon these uncontested facts, we have a winner and we have a loser. And that's a motion for summary judgment. It's a comprehensive document because you have to basically file two two things at a minimum. You have to file your motion, which sets forth the factual allegations, as well as a legal memorandum as part of that, showing you why under the law you're entitled to judgment. Then you also have to prepare and file a separate statement of facts that supports, basically, I talked about those uncontested facts. You file this separate statement of facts that contains all of your uncontested facts and has exhibits or your evidentiary support attached to it and references that. And you file that in conjunction with your motion. And that's a pretty detailed document as well. So it is a relatively complex process to file a motion for summary judgment, but that is the quickest way then to get your case in front of the court and try to obtain a resolution short of trial. Another option, and Brian kind of talked about this, which is, you serve your complaint, and then a lot of these resolve fairly quickly, before an answer is even filed. Well, even once an answer is filed, you could go into court and say, look, Judge, every case, at least here in Maricopa County, every case that's filed, local rules require that the parties go to a settlement conference. So instead of waiting 4 months, 5 months, 6 months for a settlement conference, why don't you please, or we request, Judge, that you set a settlement conference here in the next 60 days and, require that the parties attend it for hopefully an early resolution of the lawsuit. And then you go to the settlement conference, and then maybe you can avoid filing that motion for summary judgment, even though at the settlement conference you say, hey, look, our next step is a motion for summary judgment, and here's what that looks like. And you leverage that as against the other side to try to resolve the case. So that's another option for a quick resolution. But really, absent those two things, the granting of a motion for summary judgment or a settlement, the case could end up going to trial.
So let's talk about risk to the investor here. I mean, is this really the biggest risk to the investor who's hoping to leverage the sale of this property and get it done, is that he may or she may face a contested action?
Yeah, that is really the biggest risk, is the contested action. And, once an action is contested, you have everything that's associated with contested litigation. You receive an email from the court, and that's time that goes down on the billings. You receive an email from opposing counsel, that's time that goes down on billing. You receive a call from the court, just, it could be as simple as calling your paralegal and scheduling something, but that's their time and what they bill for. A call from opposing counsel. Some opposing counsel love to call you almost daily about these types of cases. And, all of a sudden the fees are going up. As litigators, and I mentioned before, I no longer litigate, but when I was a litigator, those are the things I can't control.
Sure.
I generally have a pretty good idea of how long it's going to take to draft something. I control that, right? But I can't control how many times opposing counsel calls me. And frankly, it's unprofessional not to call them back. In fact, our ethical rules require that we communicate with them and call them back and don't ignore them. So they email us and we have to email them back. And all of that adds up. And the attorney's fees could potentially escalate fairly quick. And that is the biggest risk with an investor when a seller won't perform and they're contemplating filing the specific performance action, is what does it look like if it's contested? And it can be expensive.
Yeah, I mean, the whole strategy, and it's still a good strategy, but the strategy relies on the idea that the seller, the person you're trying to force to perform, is going to be reasonable, is hoping to sell the home anyway, and isn't going to want themselves to pay a lot of money in attorney's fees to fight that. And cooler heads are going to come together and essentially get the deal done. We know that statistics bear out in such a way that that's not always going to be the case, and you got to factor that risk into your calculation. With that, we really appreciate everybody being with us today. Join us next week. Next week, we'll be talking about how to best evaluate a real estate investment and avoid the top 3 legal pitfalls. With that, thanks for being with us, everybody. We look forward to seeing you next week.
Have a good day, everyone.
Night.